Okay, thank you. So, real briefly, we will also be meeting on Monday and we'll also meet on Tuesday. Monday will be after recess, or I'm sorry, after appropriations, 5 minutes after appropriations. Tuesday will be our regularly set time. That's on the calendar. So, um, I am going to start at the top of the agenda and hearing from committee members, I will at the appropriate time entertain a motion to take the ones I'm about to mention up in block. Senate Bill 2138, Senate Bill 2697, Senate Bill 2707, Senate Bill 2717, and 2726. Just real quickly, these are bills that are bringing forward code sections and 2138 Supreme Court districts. As many of you know, the federal court has issued a redrawing of the Supreme Court districts, and that is what these code sections are doing as we need those. We have to talk to the House, obviously, and get those squared away or get the plan squared away. So that's where we are. The neglect 2697, neglect and delinquency, bringing forward the code sections that is related to the youth court. As many of you know, we are doing what we're calling the reforms. This is bringing forward those code sections. Also, as was, if you saw the discussion in Judiciary B today, that was relevant to youth court code sections, and maybe something can be addressed in there. Then 2707 AOC and intervention courts speaks for itself. That is addressing different items for the Administrative Office of Courts. And on 2717, that is double referred. And I want to mention that we have requested, last year we requested a audit of the My Kids system in youth court. And that audit, as y'all know, came back. It has been favorably received. The overview is that we are in desperate need of a new computer system or management system for My Kids. It will no longer be called My Kids. And this is bringing forward those code sections and changing everything, replacing My Kids with the computer system, management system that is going to be used. The appropriations will be taking up that side of it. I've talked to the House. They are in favor of replacing the computer system that we have for My Kids, and so that's what these will do. Then 2726, the Mississippi opioid settlement. We've had a number of bills in Jud A that will address operations of the commission, and I know the House is coming forward with theirs. The short version is that there were some questions raised about, well, I think all the recommendations were good. There were some questions about the procedure and process, and that's what these code sections and the bills are aiming to get at. And so that's the brief explanation of those. And if I have a motion to bring them up in block, I'd entertain that. So Senator Kirby moves to bring them up in block. Any opposition to that? Okay. See no opposition. Any discussion? No discussion. Do I have a motion? Motion is title sufficient, do pass. All in favor, say aye. All opposed? That carries. Thank you very much. I want to go now to Senate Bill 2890, and Ms. Pat, that can be passed out. Yeah, no, she's got that. So briefly, well, I'm not going to say briefly, what this bill is doing, there's come to our attention some issues, to say the least, in what's called the Judicial Operations Fund. You will notice that this bill is double referred to appropriations, so we want to get it to appropriations. You also have before you a proposed committee substitute. By way of background, what the Judicial Operations Fund is a separate fund that was set up to fund the operations of the courts. And flowing into that fund are different fees and costs. You will have in front of you, thanks to Taylor, his handwritten diagram. I thought it was so cute. We would hand it out, but it's very effective. This is a diagram of the fees that flow into the fund, that are supposed to flow into the fund. And you notice I said supposed to. It's been brought to appropriations attention that well, let me back up. You also know that we, the legislature, have provided raises in the last number of years, last couple years. We've also, before the Appropriations Committee, our raises requests for our judges. It was presented to us this earlier in the session that by LBO that this fund, in short, does not have the money in it to cover the operations of the court or the raises. The questions as to why and what, that's what we're looking into in appropriations. But the fact of the matter is that the funds are not appropriately there to cover all the requests that have been made, or even necessarily the operations. So we're having to look at a lot of things of how we're going to do things and what that means for operations of the court. I do appreciate Ms. Sirkin for bringing this to our attention, and LBO and their hard work, because they have put forward a decade's worth of information that shows that money that's there to fund these things is no longer there. Now, before anybody gets ahead of it, nobody's saying there's any fraud or anything like that. And that takes me to what this bill does, which is this bill has fees throughout. We fund the operations of the court system through fees, through what we file, different people file, and criminals, when they get assessed. That's what this diagram is showing you. But the fact of the matter is that the fees that are in there are not sufficient enough to cover the expenses, which leads us to, we're going to have to raise fees for different filings, and thus the code sections before you. These discussions have to go on with the House, and so we're getting there, but that's why you have the code sections before you. And so what you also have before you is a proposed committee substitute, and in that proposed committee substitute, what that does is that it brings the code sections forward, but in section 1, it repeals the Judicial Operations Fund. Mind you, this goes to appropriations. The question becomes, well, how do you fund that if that goes away? Well, that's for the appropriations to decide. But generally speaking, you won't have that fund where the money would go, I guess, to the general fund. So that's what the proposed committee substitute does. And as I understand, there's references to this fund throughout the code. And so that would be to make it conforming. It would conform to the code section with that. So that's and just to finish, there is a lot of moving parts. On Monday when we meet, the plan is to hear about it. I'm going to call it a youth court day. So you can be here on Monday because we're going to discuss youth court. But between youth court, the operations fund, the raises that have been requested, there is a lot of moving parts in the court system, and we need to get those straight. But I've said that it's a third branch of government, and we have a duty to address and get these things working and in a manner that the citizens of Mississippi can be proud of. So that's kind of the moving parts that's going on with that. So with that, I will open it up to questions. If I don't have any questions, do I have a motion? The committee said adopt.
Will you adopt? The committee sub?
Yes.
I move to adopt the committee sub.
Motion is to adopt the committee sub. All in favor, say aye. All opposed? The motion is title sufficient, do pass committee substitute. All in favor, say aye. All opposed? That carries. Thank you very much. All right, going to Senate Bill 2730. This is a bill from, and it's, I think, very timely, from Senator McMahon. And it is an immunity bill, but the immunity that it is allowing for takes place only during an emergency, a declared emergency. And as Senator McMahon explained it to me, that there are nonprofits and churches that open their doors during declared emergencies, and actually ones that could do it don't do it because they're afraid of the liability. And this, during a declared emergency, grants immunity to any nonprofit and church that opens their doors should something happen. And the hope is that there will be more that would offer their services like that. So with that, I will open it up to questions. And Senator Thompson.
Thank you, Mr. Chairman. I don't seem to have a copy of the bill in my packet, but just, are there any exceptions for gross negligence or willful misconduct or anything like that?
No, there are no exceptions for that.
Thank you, sir.
And I will say that I guess practically speaking, there would have to be, obviously, you can't just say there's a thunderstorm outside and and get the benefit of the immunity. It would have to be excuse me, like the ice storm that we're having that would trigger the statute. Any other questions? Senator Simmons.
Thank you, Mr. Chairman. In light of Senator Thompson's question, I certainly understand what Senator McMahon is trying to achieve. Would it be a friendly amendment to put a reverse repealer in it?
Short answer is yes.
Okay, so my motion.
Why you act so surprised?
I just never know with you, Mr. Chairman.
I know it's not often, but
Mr. Chairman, at the appropriate time, that'll be my amendment.
okay.
Yep.
Any other questions on the bill? Okay, we're on the amendment. The amendment is a reverse repealer. Any questions on the amendment? All in favor of the amendment, say aye. All opposed? All right, the amendment carries. We're back on the bill. Motion is title sufficient, do pass committee substitute. All in favor, say aye. All opposed? The ayes have it. Thank you very much. All right. Moving on, and I want to say thank you to the subcommittee chairman for their hard work. And with that, I'm going to turn it over to Senator Thompson for the next bill.
Thank you, Mr. Chairman. Members of the committee, the first bill we have is Senate Bill 2135. This comes to us from the circuit clerk's offices. There's currently under the SEMS system, the system itself designates between active and inactive voters. Currently, what most counties do is they only issue jury, and well, let me back up. The distinction between active and inactive is if the county has sent mail to a voter and that mail has been returned as undeliverable or no longer lives here or anything like that, that voter is entered into the system as an inactive voter. Currently, when the clerks issue the jury summonses, those only come from the active voters within the SEMS system. There was I believe it was a Mississippi Supreme Court decision that said we don't distinguish between active and inactive voters, that if you're a registered voter, you're a registered voter. So what the clerks are asking is to make sure that hopefully enough jurors show up that they don't have to issue summonses to inactive voters, that they would only continue to issue summonses to the active voters. The thought being that if, I don't know what the numbers would be, but if they issued 70 summonses for trying to get a jury pool and they only have 40 show up, you wouldn't have enough potential jurors potentially to impanel a jury. So what they've asked for is the ability to use that designation within the SEMS system to only issue summonses to active voters within the system. It does not remove anyone from the voter rolls. That's a brief explanation of the bill. Happy to answer any questions.
Questions? I have a motion.
My motion would be titled sufficient do pass.
Motion is title sufficient do pass. All in favor, say aye.
Aye.
All opposed? That carries. Thank you very much. Senate Bill 2360.
Thank you, Mr. Chairman. Senate Bill 2360 tries to address a really pretty nuanced situation in the state of Mississippi. We have, under the Mississippi Tort Claims Act, there are entities that may appear to be a private entity, but they're actually qualify for the limitations under the Tort Claims Act. It can be very difficult for a potential claimant to know whether or not an entity is covered by the Mississippi Tort Claim Act. An example would be there was a vehicular accident involving a garbage truck. The garbage truck was owned by a private entity, but because of the nature of the contract between the garbage truck company and I believe the county, that claim was governed by the Tort Claim Act. Another example could be private utility contractors. Some of those may be governed by the Tort Claim Act. So that the Tort Claims Act comes with specific timing requirements of when you have to file the claim, how you have to provide notice of the claim, and a limitation on potential, a cap on damages. What Senator Hickman's seeking to do with this bill is to make a registry of those entities that are covered by the Tort Claim Act. So if you get a claim against what looks like a private company that would be governed by the 3-year statute and everything else, you can quickly the plaintiff's attorney or the claimant could quickly cross-reference and determine whether or not that entity or potential defendant is governed by the Tort Claim Act.
All right, Senator Hobson, question.
Thank you, Mr. Chairman. Senator, help me understand this. If you're a private entity and you're contracting with a government employer, you wouldn't be an employee, you'd be an independent contractor, correct?
That's apparently not the case in some instances. And when they're depending on the services that they're providing, they can be governed by the Tort Claim Act.
I've never seen that before, and there may be a case on that or a ruling. Is there a ruling that determines that a company that contracts with the governmental entity would be considered an employee?
That's my understanding, yes.
Interesting. So under that scenario, the private entity would get the protections of the Tort Claims Act, just like the governmental entity. Is that your understanding?
The protections and the notice requirement for the claim and the reduced
Well,
claim filing period.
I'm assuming when I say protections, I'm referencing the $500,000 limit on damages. I'm referencing the notice prior to suit being filed, the 1 year statute of limitations, all those things that go with the Tort Claims Act.
That's my
So
understanding.
you don't think that a individual that may be harmed by both the governmental entity and what I'm calling the private contractor or employee, you don't think they would have a separate right of action against or cause of action against that private company? You think they'd be protected by the Tort Claims Act?
That's my understanding from Senator Hickman, is that there is a case on that point. And I'll assure you, Senator Hobbs, I'll get that case for
Okay.
you.
Yeah, that maybe there is. I just never seen that before. I would assume that there would be a separate claim and cause of action against that private entity as an independent contractor. But I don't know that. But thank you. I would like to look at this a little bit more in depth before we take this to the floor. Thank you, Mr. Chairman.
Senator Turner Ford.
Thank you, Mr. Chairman. And so private entity, would that also include a nonprofit?
So the question is, could a nonprofit be governed by the Tort Claim Act?
Yes.
I don't know the answer to that. But under this bill, if they were governed by the Tort Claim Act, they would just have to register with the Secretary of State. So that you would know.
I'm going to pause now.
Are you withdrawing your question?
Well, I am. I think I probably need some more information.
Do you want it stricken from the record?
No. I'm just going to yield the microphone. Thank you.
Oh, Senator Hickman.
Senator
Yeah.
Hickman. Mr. Chairman, I ask that
Senator
Hickman be recognized.
Subcommittee Thompson is doing a great job trying to defend your bill. So Senator Turner Ford, you're welcome to ask him about it.
Oh, okay, so thank you, Mr. Chairman. So this is, I think what I understand this situation to cover is
This Tort Claims Act.
tort claims, and this is an entity has contracted with a county or city, and they're performing some service. And it is not apparent that it is performing this governmental function. And so what this bill proposes to do is require that the Secretary of State will maintain a registry whereby anyone can go and check and determine that this entity will be covered by the Tort Claims Act. Am I understanding that correctly?
Yes, that's absolutely correct. But there are also some entities, like I've run into it, where a county and a municipality have come together and form a quasi-governmental entity that doesn't have the city or county designation. And so one would not know that they fall under the Tort Claims Act. It's simply a registry, so someone would know if this entity is performing a function of government that covers them under the Tort Claims Act.
Thank you. And so at the appropriate time, I would like to be recognized for an amendment.
Okay.
And my amendment would be that we would also add language that said entity would identify itself as performing a governmental function on its forward-facing website and written materials.
Can you just, for ease of counsel, can you point out and restate your amendment kind of where in the bill?
It would be, I would say, subparagraph 3. And for any entity that is performing a governmental function shall identify on its website and its written correspondence that it is covered by the Mississippi Tort Claims Act.
Senator Turner Ford, if, just for clarification, when you say any entity, are you talking about the contracting entity or the government entity?
This private entity will identify itself as having, been in contract or performing these governmental services. I can clean up the language later, but that's the concept of the amendment.
So, you've heard the amendment. Any discussion on the amendment?
Not for me, Mr. Chairman. I would just say that I'm happy to entertain any amendment. This is just something that's very in principle just to protect people and to help people out. And so whatever this committee wants to do with it, I'm fine with that.
Senator McCon has a question. We're on the amendment.
So on the amendment that ties back to your original bill says the Secretary of State shall create a publicly accessible registry. So in that situation, you would be asking for the Secretary of State to make a determination. But in your situation with your amendment, it sounds like you're clearing that up by asking the entity itself to declare on their own website that they are subject to the provisions of, is that what I'm understanding out of the two? And I think both of you are trying to talk, but Senator.
Senator Turner Ford, that's your amendment, so.
It is, thank you, Mr. Chairman. It is my amendment. I think, I like what the bill is attempting to do. But if you have no idea that you even need to go and check the Secretary of State's website, I think that this needs to be identified on some forward-facing material or print.
And I think that's what I was getting at, was I feel like you're asking for them to, if they feel like they're subject to the provisions of the Tort Claims Act, then they should fully identify themselves so that no one's making a determination. And we're not asking Secretary of State to go out there and do that, but you're asking for them to go ahead and declare we are subject to the Tort Claims Act.
Yes, if that's a defense that you would later raise, that you're subject to the Tort Claims Act, you need to let people know, and they should not have to engage on this search.
And if I can add to that, that's actually intended as bill, and I spoke with Chairman Thompson. This is very conceptual. That's why I think this is one that absolutely this process will make it better. I think that the idea is that they would, the Secretary of State or whoever, whatever entity we sent this to would just keep the registry. The onus would be on the company or the municipality county that's contracting with these people to send that information so that they could be there. But the idea that Senator Turner Ford is advancing is just that we want people to be able to readily identify that they're dealing with entities that are covered under the Tort Claims Act.
All right, we're still on the amendment. Any further discussion on the amendment? You want to read it? You want to read it? All right, I'm gonna ask Ethan to read out the amendment. He understands.
It would be a new subsection 3 after line 13. Subsection 3, any private entities required to register under this section performing a governmental function shall post notice on their forward-facing website of such or other materials as being under this chapter, which would be Title 11, Chapter 46.
If I may also add, printed materials.
Okay, you've heard the amendment. We're on the amendment. Any further discussion? You have a motion, Senator? I assume it's to adopt the amendment. Okay. All in favor, say aye. All opposed? Okay, amendment passes. We're on the bill as amended. Any further discussion? Senator Hobson.
If there's no further discussion, I would move that we add a reverse repeater to this bill. I still think it's got a lot of work to be done, and I've got a lot of questions that get answered. And rather than staying here for another 30 minutes or so to debate some of these issues, I would love to meet.
We are lawyers
Senator-
after all.
Senator Hickman for a
Mostly.
while and talk about this and get some examples and cases to look at. So my motion is to add a reverse repeater.
Okay,
Can I?
we're on the motion, speaking on the emotion.
Yes, I have no issue with that. And I just want to add that I would like to work with anybody. I just think this is something that protects people or whatever. So I absolutely support that motion. And I like to work with whoever would like to add something or take something away to make this a good piece of legislation.
Okay, you've heard the motion. All in favor, say aye. All opposed? All right, we're back on the bill. Do I have Thank you. Title sufficient, do pass, committee substitute. All in favor, say aye. All opposed? That carries. Thank you very much. Moving on to Senate Bill 2362, Senator Thompson's bill.
Thank you, Mr. Chairman. What Senate Bill 2362 would do is add a private cause of action under the Unfair Trade Practices Act. We passed this bill last year out of this committee and out of the Senate floor, off the Senate floor. It died in the House. Under the Unfair Trade Practices Act, Section 7524(5) sets forth 18 very specific prohibited acts and business practices that mostly deal with unfair methods of competition, unfair and deceptive trade practices, misrepresentations, that sort of thing. In the civil practice world, oftentimes you come across fact patterns where, it's questionable whether or not there's even a contract to have a breach of contract claim. You've got these quasi contractual claims, and so oftentimes the prohibited acts set forth in the Unfair Trade Practices Act fits that fact pattern better, but you currently don't have a civil cause of action. Those trade practices, or those prohibited trade practices, are limited to enforcement by the Attorney General's office. What this would do is starting on line 31, I'm looking at the strike-through version, so my numbering may be a little off, but beginning around line 30 or 31, it gives the claimant an option to either go through the Attorney General's office or to file a civil cause of action. In subsection B, starting on line 33, if a plaintiff does choose to file a civil cause of action, you have to notify the Attorney General. And then on line 38 in subpart B2 sets forth the venue of where the private cause of action should be brought. That's a brief explanation of the bill. The only thing I'd add is that there are other states, I know Louisiana for certain, allows for a private cause of action under their Unfair Trade Practices Act. It does not create any extra contractual damages or extra or special damages. It just simply gives the claimant that cause of action. That's a brief explanation of the bill. Happy to answer any questions.
Thank you. All right, any questions? Senator Simmons.
Like Chairman Hobson said a minute ago, I don't have a lot of questions, but I don't want to spend 30 minutes regarding questions. So if we can put a reverse repealer in this and keep the bill moving, Mr. Chairman, if Senator Thompson agrees.
That'd be a friendly amendment.
Thank you, Mr. Chairman.
You don't have to load up every bill with a reverse repealer. I'm just saying.
We're at the quota.
We may be at the quota, but this bill sponsor said he didn't have a problem. So that's where we are. So we're on the amendment. All in favor, say aye. All opposed? That amendment carries. Any further discussion? Have a motion. Title sufficient, do pass that committee substitute. All in favor, say aye. All opposed? That carries. Thank you. Now, on to Senate Bill 2754. We are going to try this one again. We've done it for 4 years in a row, maybe 5 now. 5. This is the child support continuing past the age of majority for disabled children. This last year went all the way to the House. I think it was the last day of session, had a debate in the House, and they chose to kill it on in the House. So I am going to let Senator Boyd, there's been a change, so I'm going to let her explain that.
So the bill that you have before us is one that you've seen in this committee repeatedly from Senator Wiggins and Senator Parker, and I think a host of others. What this does is it extends the child support obligation beyond the typical age of majority for an adult who's incapable of self-support due to a physical or mental disability that existed before the child reached adulthood if certain conditions are met. And you will see for yourself that those things, the changes in the bill are actually outlined in 151 to 161 in the bill. And we have put at the request of some House members, they have asked, and then we talked to a number of chancellors. And so some of the members in here, Senator McCon, we looked at some of the issues that they may have had with that bill. And talking with a lot of our chancellors and stuff like that. And the chancellors, by the way, did ask for this piece of legislation to begin with from a family law study committee y'all did back 4 years ago, 5 years ago.
It was 5 years ago. There was a study committee of a number of things, but had chancellors from across the state. And this was one of the recommendations that was made, and also contained in that study was that I think there's close to 40 states that have some law on the books that addresses this, maybe even 45 states.
Right. So, so that's when we made those changes. But after talking to some of the House members and then talking with some of our chancellors, they've agreed that probably in looking at children who have this significant level of physical or mental disability, establishing a conservatorship, or the law does have a requirement in the conservatorship laws, a least restrictive alternative that the chancellors can prescribe at that point. And there's a number of reasons that legally you want to do this in establishing those legal conservatorships. And this something is not done a lot of times in the law, as
But
mainly.
you speak
Sorry.
closer in the microphone. I'm sorry.
This conservatorship, as we discovered in looking at this, is something that is not done oftentimes, which should be done. And so this hopefully will help parents of special needs children who need to continue these type of support. Will go ahead and go in there and establish this conservatorship. And this was working with the chancellors. This was kind of a easy process for them to do. So they'll come back before the chancellor and look to establish what that will be. This also will give the chancellor the ability, if a child does get federal support for Social Security or additional support, maybe through a trust or something like that, that they'll be able to adjust that support accordingly. So again, over 40 states do this. I will tell y'all that we all get calls as legislators that break your hearts, that kind of pull at your heartstrings. But I will tell you, the calls from the mothers that I've had when I had my name on this bill last year, who were working 2 and 3 jobs to try to set up trust funds for their special needs child. And they had a able former spouse that they were divorced from, that they knew would stop support at the age of 18. And the chancellors have told us many, many more stories. And this is one that pulls at your heartstrings. Obviously, this individual doesn't stop having this severe disability when they reach the age of 18. And when capable, support should still be maintained. This has been something that has been, the stories that I've been told are pretty outstanding. So this is what this does. We will take this again. If y'all pass this and we pass it through the Senate, we will take it again, and hopefully with this one change, and I think makes it a stronger and better bill, we'll try to get this through the House.
Thank you, Senator Boyd. And I will just state that, yes, those chancellors, and hopefully this is the process, and hopefully they can reach out to the fellow House members and explain the situation so that our friends over there will understand. I think they understand. I think there's questions, and so hopefully that will help. So any questions on the bill? Seeing no questions, I have a motion. Motion is title sufficient, do pass. All in favor, say aye. All opposed? That passes. Thank you very much, Senator Thompson. All right, moving on to Senate Bill 2031. And I will, again, Senator Barrett, I'll let you, but I'm happy to explain that, but okay. No, I was just gonna say, we have done this one in the past. It's Senator DeBar's bill. And basically changes everything, and I'm gonna turn it over to Senator DeBar.
I was gonna let Senator Barrett do it. Thank you, Mr. Chairman. This is a bill that we filed, I think, out of that task force, that law task force. Basically, it changes almost everything to 18 as age majority. As I stated before this committee, I think at 18 years of age, if you can vote, you can go to prison, you can go fight and die for your country, then that you should be treated as an adult. I think we're one of 2 states, I believe, that treat 18 still as a minority. Most others are 18 or 19. And so that's what I recall from the bill. I'll let Senator Barrett explain further if there's anything else that I've missed. Thank you, Mr. Chairman.
Senator Barrett, you want to explain your part of the bill?
I think he explained it perfectly.
And this bill, Senator DeBar is bringing forward, it's not just bringing forward, it's changing everywhere in the code that is 21 is changing to 18, relatively speaking.
That's correct. I know for the last several years, we piecemealed it like real estate contracts and so forth. And when I had council draft it, it was basically everything that was remaining that we had not passed previously.
Senator Turner Ford had a question. No? Okay. We have any questions? Seeing no questions, have a motion.
Title sufficient, do pass.
Motion is title sufficient, do pass. All in favor, say aye. All opposed? Ayes have it. Thank you. We're moving on. Senate Bill 2126, name change, Senator Barrett.
Yes, sir. Thank you, Mr. Chairman. This bill is brought to the committee by Senator Hill, Senator McClendon. Ultimately, the bill would prohibit convicted sex offenders or persons convicted of violent crimes from legally changing their names. Ultimately, it's intended to prevent those offenders from concealing their identities and their criminal histories. I think their thought in this bill would be that it strengthens public safety and keeps, I guess, a transparent nature about who that person is. So it would prohibit sex offenders and violent offenders from changing their names, legal names.
Thank you. And I spoke to Senator Hill about this, and in registering as a sex offender, it's based on your name and everything tracks. And there have been instances, believe it or not, where people attempt to change their name so as to avoid the registration. And under the registration of sex offenders, it's depending on, I guess, the category, it's every 90 days. And you have to appear at certain places. So the intent is to prohibit that and make that a separate, I guess, crime. Senator Simmons.
Yes.
Thank you, Mr. Chairman. I was trying to follow the explanation of the bill and the language of the bill. And I certainly agree that for registration purposes, if a person has to register as a sex offender, they don't need to change their name. But on line 11 of the bill, it speaks to a crime of violence. So are we bringing all crimes of violence into this new proposed crime, or are we only trying to target those individuals who are sex offenders and trying to prevent them from changing their names after they've been convicted of a sex crime?
Well, as written, it says, yeah, crime of violence. So it does say that,
Yeah.
but also.
And I guess my concern is, as you know, Mr. Chairman, the 9732, which is the crime of violence statute, it goes from murder all the way down to house burglary. And so I guess I just want to be clear on what the intent of the bill. If the intent of the bill that anyone who is convicted of a crime of violence anywhere in the state, then it should be a crime if they attempt to change their name, or is it just sex offenders?
Well, the bill says that you're welcome to address it however you feel.
Yep. So I have an amendment at the appropriate time to conform the bill to exactly how the bill was presented, which is trying to prevent sex offenders from changing their names.
Senate. Uh, Senator Barrett.
Yeah, I wish I had a rewind button. I certainly think I said violent offenders and sex offenders. Their bill, as it's written, specifically says 97.3.2, which, as Senator Simmons mentioned, those are the crimes of violence. And I think, and I'm speaking for Senator Hill and McClendon on this, but name changes, to do so, as this body knows, you file a petition with the Chancery Court, you go before, you notice, what was it called now? Vital statistics. They can send someone to court or not. But if you've been convicted of a crime of violence, I don't know why you would be seeking to change your name other than marriage. And that can be done so in the divorce, the final judgment of divorce, or the property settlement agreement. But I certainly understand the bill says crimes of violence and sex offenders. I think that was their intent. I think that's the way I explained it. If Senator Simmons wishes to offer an amendment, I know the body can vote on that at the time, but I think what this bill is meant to do is protect public safety. And I hope as a legislative body, that's what our intent is to do, is provide protection for the citizens of the state of Mississippi.
Thank you. We're on the amendment. Would you like to restate your amendment, Senator Simmons?
Just like, yeah, my amendment was on line 11 to conform it to those individuals who have been convicted of a sex offense or who have to register as a sex offender. So strike crime of violence and amend it or replace it with those who have been convicted of a sex offense or who have to register as sex offenders from changing their names.
Okay, so talking to counsel, he puts it as, it's really deleting section 1 and ensuring the penalty applies to the other ones. That's to section 2.
That's fine.
Okay, so that's the amendment. Further discussion on the amendment?
I'd like to close on the amendment.
Okay, you can close.
Yep. But thank you, Mr. Chairman. Members of the committee, I guess the part that bothers me is, do we want those convicted of a crime to be able to change their names at all? I mean, because we're leaving out nonviolent offenders, but then we are very specific, as Senator Barrett presented. And I'm sorry if I actually didn't hear you say crimes of violence, but I thought specifically what Senator Hill and McClendon was trying to achieve is those crimes that are specific to identifying who you are. And so we definitely know that crimes where a person has to register as a sex offender or sex crimes is certainly a public safety concern, which I agree with, that you don't need to have the ability to change your name. But crimes of violence, I mean people who are convicted of manslaughter, house burglary, those who are serving time in the Mississippi Department of Corrections, I guess we want to cover those individuals too. I guess if they some kind of way find a way to file a petition in Chancery Court to change their name while they serving time. So I asked the committee to support my amendment, which would speak to those individuals who are sex offenders or who have to register. Their crime requires them to register as a sex offender and to prevent them from changing their names. And if they do so, then it will be a new crime as proposed by Senator Hill and McClendon.
Okay, thank you, Senator Simmons. You've heard the amendment. The motion is to adopt the amendment. All in favor, say aye.
Aye.
All opposed? Chairs in doubt. So show of hands, all in favor, raise your hands.
On the amendment.
No. Yeah, to be clear, keeping it, we're on the amendment. Okay, all against? 7-6 in favor. Amendment passes. Okay, amendment passes. We're on the bill as it is amended.
Thank you, Mr. Chairman. I was trying to thumb through the bill to find where it's noted that is it a person who has been convicted of a sexual offense cannot change their name? Is that, so then my question would be, as I understand it, I think your name can be removed from the registry upon petition to the court. And so I guess I would like to propose an amendment, but I cannot find that language in the bill. Section 2.
Well, they're required to register, so if their name was removed, it wouldn't apply.
So this would not apply to them. Okay, thank you. Thank you.
Okay, thank you. Any other questions? The motion is title sufficient, do pass, committee substitute. All in favor, say aye. All opposed? That carries. Thank you very much. Next, Senate Bill 2377, Uniform Athlete Agents Law. Senator Barrett, your bill.
Yeah, thank you, Mr. Chairman. This bill is brought to you by the esteemed Senator Barrett, and in the age of NIL, and I know we have some House members that have filed NIL applying to high school sports agents are seriously around the state representing young adults, male and female. There was no penalty provision for someone acting outside of the scope or not registering pursuant to the rules promulgated by the Secretary of State and this body. So Section 4 would say that any person's company or entity performing any acts in the business of an athlete agent without complying with those terms, there would be a punitive measure. That punitive measure would be a $25,000 fine and shall be barred from registering under this chapter for 3 years. That's an explanation of the bill.
Thank you, Senator Barrett. And I have one question.
Yes,
So, and people may not know, but everything else in there, the athlete agent, there is actually, that's current law. We actually have a law dealing with athlete agents, right?
Yes, sir.
Okay, and so you're trying to, I guess in this new iteration of NIL and all that, you're trying to strengthen
Yes, sir.
that, and this is from the agent side of representing an athlete.
That's correct, Mr. Chairman, and you can go to the Secretary of State's website, and there's a list of hundreds of agents from Alaska to Alabama that are registered in the state, and I'm just trying to make sure that these are all good actors and representing our young adults.
All right, any questions on the bill? Senator Barrett moves title sufficient due pat. Oh,
I do.
Senator Barnett.
I have a question.
Okay.
So Senator Barrett, does this apply to a parent or a legal guardian who may be acting as an agent on the behalf of the child athlete?
This would apply to persons that are acting under the Uniform Athlete Agent Law as it is currently written. We're not changing anything in the athlete agent law, which been on the books. All we're doing now is putting some punitive measures in there for athlete agents, persons that are the agents themselves, not parents or guardians acting as that person. Now, whether they do so, I certainly don't think that's a good idea, but if they choose to do so, they're the guardians and they can act on their behalf.
So, but it's not specified anywhere in the current law either where is a parent who is acting, or a legal guardian who is acting on behalf of the child athlete to represent them versus going out and hiring a agent to do the same work.
Sure, but as a parent, I can go sign a document for my kid to buy a car. There's not a law that says that, but I'm the parent, I can do that. This is specifically referencing athlete agents that hold themselves out to be as such, and they're doing this for strictly pecuniary reasons. I mean, they're got personal gain in it. They're making 10 to 20% in fees off of what this child brings to the college or university. Are you asking, I mean, I'm trying to understand, are you asking me if a parent or guardian can represent their child?
And if they can, then would they be, do they have to register as well if I'm representing my child? Okay, so if I'm not, I see the chairman is,
I'm not a judge, but as this bill is before you today, there's nothing in here about parent or guardian.
no,
So,
but can a parent or a guardian be construed as a agent if they're acting as the agent for that child, but they haven't registered?
oh yeah, again, I'm not the judge, but pursuant to this bill, a parent or guardian is not listed in here. So if they wish to do so, I don't think that they're susceptible to the penalties because they are the parent or guardian.
Can legal,
Senator Barrett, I think to put another way, if a parent chooses to engage as a agent for their child, do they have to register under the Secretary of State as required? I think that's where Senator
yeah,
Barnett is coming.
I think so too, Mr. Chairman, and I do not think so.
They don't.
I do not think if a parent is acting, even though I think that is ill-advised, if they do so, I don't think they have to register as an agent as the law was adopted by this legislature a few years ago.
The pro tem has a question.
I do. Thank you. Thank
Yes.
you, Mr. Chairman. My question is not being an attorney. I'd like to know if they do have a fine of 25,000, who gets that money?
I would, that's not specified in here, but I think it should go into, I would say the general fund, the state's general fund.
State, not the county. Okay.
I'm sorry?
State general fund though.
Yes, sir.
Okay. Okay.
Okay, I wanted to get, because I may have cut it off accidentally. So back to Senator Barnett's question. Is that satisfied? Okay.
Yeah. Mr. Chairman, I don't know that we want to, but I certainly have no objection if Senator Barnett wants to put in here that a parent or legal guardian doesn't have to register. I've got no objection to that. I certainly don't think a parent or guardian should be fined or barred from representing a future sibling. Again, I think that would be ill-advised because there are people that do this for business, but I certainly don't want a mother, a father, a family member being fined $25,000. The nature and this bill is brought forward to protect our children that may benefit from NIL dollars or any sort of scholarship or, all this revenue sharing that's out there now. And it's getting bigger, and whether it gets into high school or not matters not to me, but I do think having people come in here, they need to identify that I am with company X, my address is this, I am a registered agent, and if you don't do that, you should be penalized, just like you would be with the Mississippi Bar or any other association. So I certainly,
I can maybe help. So council has pointed out in the current law, the definition of athlete agent and I'm quoting here, means an individual who enters into an agency contract with a student athlete, so forth. The term does not include a spouse,
Yeah.
parent, sibling, grandparent, or guardian of the student athlete or an individual acting solely on behalf of a professional sports team or professional sports organization. So under that definition, the current law, a parent does not count as an athlete agent and therefore does not have to register accordingly.
Okay. Thank you.
Mr. Chairman, if
Okay.
there are no other questions, have a motion. Okay.
Senator England has a question.
Yes, thank you, Mr. Chairman. I would just like to ask if the esteemed Senator Barrett obviously drafted that answer to that question into the bill. So I'm glad that we got that answered. Is that correct, Senator Barrett?
That is correct.
Okay, thank you. I just want to make sure.
Motion is, seeing no further questions, motion is title sufficient, do pass. All in favor, say aye. All opposed? That carries. Thank you to the last bill, Senate Bill 2718, adjudication of non-commercial DUI offenses. Senator Barrett?
Yes, sir. Thank you, Mr. Chairman. I've spoken with the Truckers Association on this bill. I know commercial driver's license are always throw up a red flag. What this bill would do is it would allow a person who is the holder of a commercial driver's license, if they were operating their personal vehicle and was convicted of a DUI in their personal vehicle, they would have the ability to get that DUI non-adjudicated, just like every other person that can get a DUI. As the law currently stands, you have to be a first-time offender and are not the holder of a commercial driver's license. This would obviously remove that as long as you were operating your personal vehicle or a personal vehicle, not driving the commercial vehicle.
And Senator Barrett, under current law, if you're a person and you're not driving, you don't have a CDL, if you're a first-time offender, you're eligible for non-adjudication. Is that correct?
Yes, sir.
And then under current law, if you have a CDL, what's occurring is even if you get a DUI in your personal vehicle, you are not being allowed to seek that relief.
Correct.
Okay. And if you know, has it not been the case that there's been a lot of questions about whether that is a equal protection clause or violates equal protection?
Mr. Chairman, I think there's been certainly a lot of questions about it, and if you were asking me to opine on it, I think it does violate the equal protection. If I have a CDL and I go out to dinner with my wife and my personal vehicle get pulled over, issued a DUI, I don't understand why I, as a holder of a CDL, driving a personal vehicle would not have the same benefits as someone who is not the holder of a CDL.
Thank you. And I will tell the committee, this has come up before. I personally have had judges and lawyers say that the issue that runs in, so be prepared, because if you hear it, that what gets thrown around this building is that, well, we're going to lose highway funds because the feds are going to say you can't do that. Well, that's a decision every person has to make, but I will tell you that that doesn't sway it for me. And that gets used as a threat that you're going to lose highway funds just because a CDL is that way. The CDL governs driving a truck. And certainly if you're in DUI in a truck, you need to be in jail or whatever. So that will likely happen. So with that, are there any questions on the bill? Senator England?
Thank you, Mr. Chairman. And I can ask the chair or the Senator Barrett, could passage of this bill result in the loss of federal transportation funds? You raise a good question. I don't know if that's a possibility or not.
It is, if you're asking the chair, it's my opinion that no, they will make that threat It's been discussed previously with people like Commissioner Tyndall and others. So will it? I mean,
I know.
I guess we'd have to see, but I don't think, I don't think that would necessarily happen, no.
Let me just ask, are you aware of any states that have lost funding after passing a similar bill?
I am not. I personally am not, no.
Okay, thank
And
you.
I've not seen any data that says that's the case.
Thank you, Mr. Chairman.
Okay. Any other questions? Senate, do I have a motion?
Title sufficient do pass.
Motion is title sufficient do pass. All in favor, say aye. All opposed? That carries. All right, and we will entertain rise and report. We will meet on Monday. Thank you very much. Motion is rise and report.
Slam my gavel.